Hello, good evening. Hope you can hear me clearly. Okay, so this is the third and final day of our revision. There's a question, is it? If you have questions during our revision before the exam, can we? Yeah, definitely you can. Right, I'll put my email address here. u.edu. Right, that's my email address. Okay, so as I said, this is the final day of our revision. So as I told you, today we will look at 2023 questions. Right, and also we will go on and look at essay questions as well, right, in regards to uh, hearsay, bad character evidence and others, right, and after that we are done, right. So what I'm going to do now is I'm going to upload the 2023 evidence answer here, right. Just give me a second, I'm uploading it now. Later it will come to your chat box. Okay, it's being uploaded. And I've also promised you, I remember, right, that I will give you the summary of the article, right? Summary of the article that you're supposed to go on and read in regards to RAG-ST. I've actually summarized it already, right? Give me a second. I will extract the summary. Just give me a second. Okay, so I will upload the summary here as well. That's a summary. So if you guys, I mean, ideally, you should go on and read the article, right? Ideally, again, you should go on and read the article. But if let's say you don't have a time or whatever, you should go on and read the summary to the very least, so that you know what the examiner's expectation is. There's a question, is it the only document sent during the revision class? Sorry, I did not attend the previous class. No, yesterday I've actually sent a different attachment, right? That was actually 2022 evidence answers, right? So that's the attachment here. I'm uploading it now. You can download. This was the attachment that I've given yesterday. Right, but you don't have to worry. All these attachments, I will send a copy to Speed. Right, no problem. You're welcome. So what I'm going to do now, we will start from 2023 questions, which will be problem solving questions. Then after that, we'll look at essay questions. 2023 has essay questions as well, right? But the answer for all the essay questions are the same, right? So we will look at some essay questions. Then I will show you the 2023 essay questions, which is actually the same. So I'm going to start with the 2023 evidence law exam question. I particularly want to do this question in class. This question that you are looking at now, 2023 actually, right? It's not 2024, right? This is 2023. I think I've mistakenly put 2024, right? It's actually 2023 question. Question 7, 2023 zone A, right? I particularly want to look at this question. The reason is because this question is in regards to RAG-ST. Right? The examiners asked about RAG-ST in this question. So I thought that it will be good practice for us to go on and look at this now so that you guys know how to answer this when it comes to exam. Look at question 7, 2023 zone A. An anonymous caller phones the police at 10 p.m. on the evening of 23rd February and shouts in an agitated tone, "A man is attacking a woman right now at 45 Compton Avenue. I just saw it through the front window of the house as I was driving past." The police rush to the address, where Alex answers the door and says that he has been home alone all evening as his wife Beatrice has gone away to the Swansea Writers Retreat and cannot be contacted. Right? He says he is a businessman and knows his rights, but allows the police to conduct quick search of the house, and where they find no one there and nothing incriminating. However, 3 days later, a dog walker finds Beatrice's dead body concealed under some branches in a stream that runs past the back of the Alex house. The body has many injuries and is covered in blood. Alex is arrested and PC Cartwright cautions him. The duty solicitor requested by Alex is taking a long time to arrive, and PC Cartwright says the interview will proceed immediately. The interview begins with Alex protesting, but Cartwright says that as a businessman, obviously knows his rights, so there's no problem. If you look at this line, see here, this part. The interview begins with Alex protesting, but PC Cartwright says that as a businessman, obviously you knows your rights, so there's no problem. If you look at this line, and if you look at this line, this is exactly the line that he repeated when the police knocked his door. Right? He said, I'm a businessman and I know my rights, but I will allow you to conduct a quick search. So the police is retaliating back only. So, PC Cartwright adds, you will also know that everything will go easier for you if you just confess now. We can easily get the scale down to manslaughter if you give us some suitable story. Maybe she was driving you crazy with her constant nagging. Alex at first denies everything, just saying that she spent the whole evening quietly working in his study at the back of the house. After 5 hours of repetitive questioning, PC Cartwright loses his temper and starts shouting and swearing at Alex and says, we know for an absolute fact that Beatrice was never even at that Swansea retreat. This is a lie, as they have not been able to contact the retreat. Alex then confesses to killing Beatrice. Meanwhile, the police have found Alex's mobile phone records, including a message sent at 8 a.m. on 24 February to Deirdre, Alex's neighbor. Do you know how to get blood stains off the leather gloves? At trial, Alex pleads not guilty and challenges the admissibility of his confession. He claims he has no idea how Beatrice's body ended up in the stream. Discuss adding critical comment where you think the law is unsatisfactory. So as you can see here, there's actually an issue in regards to confession for sure. And we have some issues in regards to section 78, section 76 sub 2A, section 76 sub 2B in regards to how do we exclude evidence, right? And we also have an issue in regards to hearsay. Actually, there are two hearsay issues here. If you look at this carefully, there are two hearsay issues. The first issue is this one. Anonymous caller phones the police at 10 p.m. on the evening of 23rd February and shouts in an agitated tone, a man is attacking a woman right now at 45 Compton Avenue. I just saw it through the front window of the house as I was driving past. This was actually told by the anonymous man to the police, right? And the second hearsay issue here is towards the end. The police found Alex's mobile phone records, including a message sent at 8 a.m. on 24th February. Do you know how to get blood stains off the leather gloves? Right? So, the first one is actually hearsay. But the first one is a rag estate. How do I know it's actually the rag estate? Well, you will get some indication in your exam. If it is rag estate, you will get some indication in your exam. What is the indication that you will get? Can you see here? Agitated tone. Sometimes the examiner will put distressed tone, panic tone. Whenever you see indications like this, it means it is actually rag estate. The examiner wants you to discuss rag estate. That's the reason the examiner have actually put clues like this. Agitated tone means like something like freaking out like that, right? That's called agitated tone. So this is actually rag estate issue. Then the second hearsay is actually the normal hearsay issue, right? So I'm going to start with rag estate. Can you see rag estate? Hearsay, rag estate. Okay, so this is how it's going to work. First, we're going to take this statement where the man said, A man is attacking a woman right now at 45 Compton Avenue. I just saw it through the front window of the house as I was driving past. Okay. Whether is this hearsay or not, we have to test this in line with Section 115 sub 3 of Criminal Justice Act 2003. Is there a question? Sorry, you said agitated tone, panic tone are indicators for rag ST. Yes. If you get this type of words in your exam, it means this is a clue that the examiners want you to discuss rag ST. Right? Because what is rag ST? In United Kingdom, rag ST is called as excited utterance. Right? So this type of a freaking out voice, freaking out tone, these are all indicating it's actually rag ST. So what you're going to do first, you put the statement and you are going to look at section 115 sub 3. Right? Section 115 sub 3, where we have to look at the definition of hearsay. The definition of hearsay is if the purpose or one of the purpose of the maker of the statement, I repeat, if the purpose or one of the purposes of the maker of the statement is to cause another person to believe the matter, then it is hearsay. And if it is hearsay, it is inadmissible. So when you get a call like that, somebody calling and says that I saw a man, hitting a woman, attacking a woman at Compton Avenue. I just drove by there. I saw it. They want you to believe whatever they are telling is true. That's the reason they are saying this. And somehow I call the police. It's not like I call my friend. When you say something to the police like this, obviously your purpose or one of your purposes is to cause someone to believe what you said is true. So therefore, this is hearsay. And if it is hearsay, it has to be admitted under one of the gateways. Right? If it is hearsay, it must be admitted under one of the gateways. So what are the gateways available? As all of you already knows, right? We have section 114. We have section 116, section 117, section 118, which is rag ST, section 121, multiple hearsay, section 114 sub 1D, which is safety valve, right? Which is actually in the interest of justice. Where can I get these notes? Oh, you just entered. Okay. I just uploaded these notes. Right. I'll re-upload these back. This is the notes that I'm referring to now. Right. And there's also an article summary that I've uploaded. Right. Wait, I'll upload that as well. Okay. So both are coming in now. Right. But I'm referring to the first attachment that I sent. Okay. So since this is actually hearsay, we should admit this, right, under one of the exception. And I said the exception here will be the exception in regards to rag ST because we get a clue from the examiner and the clue suggested that whenever there's something like frantic or agitated tone, or frantic, agitated tone, what else? Panic tone. This is all indicating it is a rag ST. Because rag ST in the United Kingdom is called as excited utterance. Right? So it's a statement that you make when you are very excited. So like for an example, like if you got to know that you have scored first class honors in your LLB, right? University of London, then you will be shouting, this is the day I'm waiting for. Thank you, God. Thank you, my mom. Thank you, my wife. Thank you, my husband. These are all excited utterance. Things that you say out of excitement. See, things that you say out of excitement need not to be the last thing that you say before you die, Right? It's like someone step you and then you say, oh my God. It's not only that. Anytime you get excited and you utter something, it's called excited utterance. So the purpose of what is rag ST? Rag ST means part of the story. Right? Part of the story. So meaning when you are part of the story, you can't lie. When I ask you to when I ask you to look right, you will look right. Right? You won't look left. It requires some practice for you to do that. When I say look right, you look left. Because you are part of the story. If I ask you to touch your nose, you will touch your nose. Right? It is impossible for you to say, or for you to do when I say touch your nose and you touch here. Right? It requires some practice to do like that. When I say touch your cheek and you did like that. Right? So when you are part of the story, it's difficult for you to lie. Because the essential problem in rag geste or in hearsay is there will be a concoction. There will be a concoction of story. Human beings are naturally decorative people. We tend to decorate story. We love to decorate story. Right? That's the reason, as all of you know, that's the reason hearsay is not really one of the credible evidence, because people tend to decorate stories. Right? So right now, if the decoration part is not there, right? I repeat, if decoration part is not there, then that particular statement can be taken into account. So case on point, you can see the case of Crown against Bedingfield, 1879. Can you see Crown against Bedingfield? Right? This is in regards to a boyfriend and girlfriend. Right? Apparently they were fighting. And then the boyfriend cut her throat, slashed. Right? And she managed to run out of the room, although her throat was cut. Right? Cut means not decapitated. Right? Obviously, you know, a headless body cannot run like that. Right? I'm talking about just a slash. Right? I just slashed it. And she ran out of the room. And she looked at her auntie and she said, this exactly she said, "Oh dear aunt, see what Harry is the name of Bedingfield. Bedingfield is the defendant. Right? Oh dear aunt, see what Harry has done to me." That's all. So in trial, the prosecution wants to adduce this as rag geste, because someone slashed her, and then she said, "Oh aunt, look at what Bedingfield has done to me." But then the court did not accept this as rag geste. Lord Justice Cockburn, he stated this is not really a rag geste. Why? Because rag geste is actually a spontaneous exclamation. Right? Your excited utterance must be spontaneous. Just like that. Right? It must be spontaneous like that. Your excited utterance. It cannot be. Right? It cannot be. Your excited utterance is you know, it's like your excited utterance is like after 5 minutes, after 6 minutes. And on the facts of the case, as you can see here, what is this? On the facts of the case, she ran out of the room. You can see she managed to run out of the room. So there's a time lapse there. Because there's a time lapse there, the court stated that's not rag geste. It must be spontaneous, just like that. Right? It must be spontaneous. Do you understand? And then you go to Ratton. There's a typo there. It's a Ratton against the Queen. Right? Ratten. It's not R. It's Ratten. Ratton against the Queen. Right? Not Ratter against the Queen. It's a Ratton against the Queen. So there's this man, Ratton. Right? He was prosecuted for the killing of his wife, murder. So his defense is this, just like Woolmington against DPP. You know Woolmington against DPP? The case that I told you yesterday about burden of proof, you must have studied that in your criminal law. You must have also studied that in evidence in your first chapter, burden of proof. Just like Woolmington against DPP, the man on the facts of this case, Ratton against the Queen, said that the gun accidentally went off. Right? The gun accidentally went off. So accidentally went off, and then it has actually hit the wife, and the wife died. That was his defense. But then the wife apparently, right, took the phone and called some random number, right, and it hit the telephonist, one of the telephonists. Right, called some random number, it hit the one of the telephonists, and she told the telephonist, right, the telephone operator, "Get me the police, please." And before the operator connect the police, the line was cut. So the prosecution wants to bring this evidence as a rag geste, because you say that the gun accidentally went off. If it is accidentally went off, nobody will go and call the police. Right? Or because they know that it's a mistake. How they will call the police when the gun has accidentally went off? So this is to show that the gun was not accidentally went off. Right? It was a murder. And the court stated, this is actually a rag estate. Right? So you can see here, her call in distress showed that shooting in question was intentional and not accidental. And therefore, it was admitted. The statement by the lady to the telephonist was admitted as a rag estate hearsay statement. Do you understand? So, you must think about this. See, what is actually the difference between Bedingfield and Ratton against the Queen? See, in Bedingfield, she ran out of the room. Right? Probably, she fell and then she was, holding on to something and she stood up and then she walked 2-3 steps, then she fell down again. And then she hold into something or she held something and then she walked out of the room and she said, "Oh, Aunt, see what Harry did to me." Harry is Bedingfield. Then this lady also, she was shot, right? Again, she must have fell and then she held onto something and she went out and she fell and she held into something and then she went out of the room or went near to the phone and she called somebody randomly and said, "Get me the police." There the court stated it wasn't a hearsay. The exception of rag estate is not applicable. But here the court is telling the exception is applicable. It's very difficult for us to distinguish this. Is there any question? It looks like somebody has posted something. Okay, now mind. Okay, so again, as I was telling, right, you must actually go on and make a distinction between these two cases, Bedingfield and Ratton against the Queen. You must able to show to the examiner why these two cases are different. Actually, there's no reason, I would say. Right? There's no reason why I would say. I think that it's the same, but then the court is actually giving a different judgment for different cases. Then comes the case of Crown against Andrews. Can you see the case of Crown against Andrews? So if you see the case of Crown against Andrews, right, in this case, Lord Justice Ochner, right, he actually came up with his requirements for rag estate. And these requirements are the one that today we call as Ochner criteria. Today, remember, if you want to fall in rag estate, right, if you want to go on and describe or define rag estate, you must go under Ochner criteria. Do you understand this? And what is Ochner criteria? We are going to look at this now. Ochner criteria is number one. For rag estate to be admitted, the possibility of concoction or distortion must be disregarded. There cannot be any room for someone to decorate the story. Right? There cannot be any room for someone to decorate the story. If they can decorate the story, it is not rag estate. Because in rag estate, you are part of the story. You cannot be decorating the story. You get this? And number two, if the event is so unusual or dramatic, spontaneous exclamation can be presumed. Right? If the event is so unusual or dramatic, spontaneous exclamation can be presumed. Like for an example, someone took a knife and stabbed you. Someone taking a knife and stabbing you is not everyday occurrence. It's something very, very uncommon, even to you. Right? And number three, spontaneous statement must be closely connected to the event causing it. That means, it must be like whatever I'm doing, and your statement must be related to that. So what does that mean? Like when you smell, and you say that what a nice smell. But when you smell, and you say that tomorrow I'll be going to university, that's not really connected. Right? That's the reason they say spontaneous statement must be closely connected to the event causing it. So when you smell, it must be something related to the smell. Right? Number four, not likely to have special features making concoction or distortion. What is these special features making concoction or distortion possible? Right? Meaning, there cannot be, right, any sort of special features making concoction or distortion possible. What is the special feature that always make concoction or distortion possible? When you say this to someone, when they say that to someone else. So this reg ST, as long as its percent transaction is better. If reg ST goes few rounds like that, then there are some special features making concoction or distortion possible. And no special feature to result in error. Right? There's no special feature that result in error. What is these special features? These special features and these special features are the same. Right? This special feature and this special feature is the same. So as I told you, right, multiple hearsay is always considered to be a special feature. There cannot be any sort of special feature that makes concoction or distortion or errors possible. Right? Errors in our judgment. This is the Ackner criteria. And today, when it comes to any hearsay question, you have to discuss Ackner criteria. Anybody have any problem? Okay. So, let us go on and look at whether this statement is admitted or not. Do you think we can satisfy Ackner criteria here? Most likely, I think yes. Right on the facts. Because the police suddenly got a call and there was actually a person said that I saw someone was attacking a woman in Compton Avenue. Right? And after that, the line was cut. Right? So I think most likely the statement can be admitted as reg ST. Right? And remember, today you have to write down Ackner criteria. So if you say it is admissible, you must say why it is admissible, right or wrong? So why it is admissible? You must able to say that the possibility of concoction or distortion, right, is disregarded on the facts. Right? Why it is disregarded? Because it was actually a distress call. Right? It was actually a very sudden distress call. Do you understand? That's reg ST. Okay, so now you go to excluded confession. It seems on the facts, there was a confession recorded. Right? There was a confession recorded because the question stated, Alex has confessed to the crime and sought it to be excluded. So if he confessed to the crime and if he wants to exclude it, then he can do it via 4 ways. Right? He can use, right? If he wants, he can use section 78, section 82 sub 3 of Police and Criminal Evidence Act 1984. He can also use section 76 sub 2A and 76 sub 2B. Right? 76 sub 2A and 76 sub 2B of Police and Criminal Evidence Act 1984. So first of all, if you want to go under 2A or 2B, first you have to satisfy it must be relevant. Right? The particular evidence must be relevant. Let's see, is there a question? Why on these facts possibility of concoction is excluded? You're asking for reg ST, is it? Possibility of concoction is disregarded here. It's because if you look at the question, right, suddenly someone called, right, and said that in an agitated tone, right, someone attacking another person. So I said that they are in an agitated tone. So most likely they are panic, right? And if they are really panic, then obviously concoction is disregarded. Now, obviously, I don't know as a matter of fact whether this man is doing a drama or whatever, right? If let's say, if he's acting like he's panic, then obviously, possibility of concoction or distortion is not disregarded there. But I assume that the man is really in panic state. That's the reason I said any concoction or distortion can be disregarded. Any question? Okay. So, as you can see there, right? First of all, we have to decide whether it is relevant, right? You're welcome. You have to decide whether it's relevant or not. Is it relevant? The fact that accused confessed to his crime? Accused confessing to his crime is always considered to be relevant. Right? Accused confessing to his crime is always considered to be relevant because he admitted guilty. If he admitted guilty, what is relevant? Remember yesterday I told you this. What is relevant means? Facts proving facts in issue is relevant. Facts proving facts in issue is relevant. What is facts in issue? Facts in issue is AR, MR, defense. So anything goes towards proving AR or MR is always considered to be relevant, right? And Alex confessed to the crime. He said that he is guilty. If the accused himself is saying that he is guilty, it's one of the factors that we'll take into account before sentencing, and therefore the statement is considered to be relevant. Okay. Second, it must not be excluded under 76 sub 2A or 76 sub 2B. So as usual, you go to 76 sub 2A, which is oppression, evidence obtained by oppression. And you have to define what is an oppression. So you can see in 76 sub 8, oppression includes torture, inhumane or degrading treatment, and the use or threat of violence. You can discuss this, or you can discuss the case of Crown against Fulling. You can discuss either one of these without any problem. So on the fact, is there an oppression? You can see on the facts, the police were questioning him for 5 hours repetitively. PC Cartwright, right? The question indicated PC Cartwright loses his temper and starts shouting and swearing at Alex. That's maybe an oppression. Remember, oppression need not to be physical. Mental oppression is also considered to be an oppression. Then, yeah, so far those are the two things. So I said if the court consider this as inhumane or degrading treatment, then confession has to be excluded. Right? But it depends on the court. What is AR and MR? MR is what you studied in your criminal law, right? Which is actus reus, mens rea, right? The criminal law, AR and MR, how to establish AR, how to establish MR. That's the same thing I'm talking about. Actus reus and mens rea. Okay. Any issues? No problem. You're welcome. So 76 sub 2A is done, right? Oppression. Now, please remember, anytime you discuss 76 sub 2A, you must always tell this to the examiner, right? For 76 sub 2A to be applicable, impropriety by the policeman is required. That means the policeman must have acted in bad faith. The policeman must have acted in bad faith. Then we go to 76 sub 2B. 76 sub 2B is something said or done by third parties. So again, you have to put the case of Crown against Goldenberg, where in the case of Crown against Goldenberg, it was stated that something said or done must come externally from the policeman or from anybody. Once something said or done comes externally, all the internal characteristic of the accused can be taken into account. But something said or done must come externally. You get this? Now, all these things I've looked at 1,000 times with you already. I mean, it's a figurative speech, obviously not 1,000 times, but I think like 9-10 times most likely, right? So, can I know anybody have any problem here? Because we have problem, then once and for all. See here, at this point, I want to explain to you something. Sometimes, some questions will say this. The accused is a drug addict, but the police came and told him that if I supply you drugs, would you confess? And he said, okay, I'll confess. So he also confessed already. Then after that, he wants to exclude the confession. He will say that something said or done. And you know what the police officers will say? The police officers will say, judge, or your question will be as such. The question will say that the police officers just asks you whether you want drugs or not. A normal man, if you go and ask him, do you want drugs? He will say, no, I don't take drugs. But then who asked you to take drugs? Do you understand what is the problem here? Right? The policeman will say that, judge, a normal person, if we go and taunt them that you want drugs, a normal person will say, I don't take drugs. But why this man, right? When we say that we will go on and give you drugs, he confess. Obviously, prosecution can say like this. But please remember, the moment something said or done comes externally, all the internal physical or mental characteristic of the accused can be taken into account. Meaning to say, right, the moment something comes externally, after that, the confession can be excluded without any problem, despite of the fact that you are a drug dealer. I cannot say that, a normal man would have acted differently, right? Because in evidence law, right, the rule in regards to this is very strict. Do you understand this? Right? As long as something comes externally, all the internal characteristic can be taken into account. But something said or done must come externally. So put the case of Crown against Goldenberg, right? And then if you want, you can also discuss Crown against Paris, right? This is the facts of Crown against Paris. Mullah Abdullahi, remember, right? From yesterday, I've been repeating these facts to you. What is that? He was questioned for 300 times over his involvement in the breach, right? Which he always denied. And that was actually taken as something said or done as well. So on the fact something said or done must come externally from PC Cartwright, right? And these are the things that was said and done. PC Cartwright stated, you will know that everything will go easier for you if you just confess now. We can easily get this scale down to manslaughter if you give us some suitable story. Maybe she was driving you crazy with her constant nagging. That is something said or done, right? You have said it. 5 hours repetitive question is also something said or done. PC Cartwright loses his temper and starts shouting and swearing in a relax. That is also mental operation. So on the fact, we have to decide whether the 76 sub 2B or not. Can we discuss 76 sub 2B here? Most likely, yes. Right? If there is something said or done. Okay, then we go to confession, section 78. So all these things we want to exclude the confession, that's the reason we are struggling. Right? We just want to exclude the confession. So again, section 78 is whenever there's an adverse effect to the fairness of the proceedings, the statement ought not to admit. Right? Whenever there's an adverse effect on the fairness of the proceedings. So again, this is the introduction. Right? Together with the case of Crown against Sang. Remember Crown against Sang? When prejudicial effect outweigh the probative value. Right? That is Crown against Sang. Okay. So what are the, I'll always say to the students that you try to exclude Code C breaches under section 78 or section 76 sub 2B. Okay. So on the fact, what is the breach of the Code C? You can see I put the breach. This is the breach that I've already done analysis yesterday, I think. I explained to you how this particular Criminal Justice Act 2003 admissibility section works. Right? So you must be aware of this. Okay. So can you see breaches of Code C? Para 12.8. Breaks at recognized meal times and short refreshment breaks at interval of 2 hours. But apparently on the facts, for 5 hours, he was actually treated. He was interviewed without a break for 5 hours. So therefore, I stated that most likely the evidence can be excluded here. But again, it depends on the court. Right? If you ask me, I would say that the evidence can be excluded. Right? The confession. Right? Because 12.8 is actually a significant breach. Right? Where you are not even giving food at intervals of 2 hours. Right? So, after this, please write Crown against Kinan, Crown against Kennelly. Right? And what they have stated, only significant and substantial breaches will be excluded. Only a flagrant, deliberate, cynical will be excluded. So as I told you yesterday, a single breach will not warrant an exclusion. I repeat, a single breach will not warrant an exclusion. There must be group of few breaches. Only then we can say there's a violation. Anybody have any question here? Okay. There's one small issue that we have to look at. If you look at this question, right? If you look at this question, this part. Can you see the last part here? Right? In the first paragraph. This is a lie, as they have not been able to contact the retreat. So, it was a lie. Now, what was a lie? The part that we have actually, found, what is that? Yeah, the fact that, Beatrice never been to Swansea retreat. Because the question itself indicated that they have not been able to contact the retreat this year. So, how about lying to the police? Is that considered to be, what do I say? Lying to the police, is that considered to be a illegal thing? Or can you just simply lie to any police? Let me go to that particular area. Yeah, this part. Page number 4. Remember this, guys. Remember this. Yesterday also I told you this. You can lie to the accused, no problem. You can lie to the defendant, no problem. The only person that you cannot lie is the lawyer. Right? So if the policeman go and lie to the lawyer, it will be taken as abuse of process. So I quoted the case of the case of Crown against Mason. You can see here. Right? The case of Crown against Mason. Do you know what happened in this case? Crown against Mason. Likewise, I told you yesterday, the policeman came and lied to the solicitor that we have already found, right, the fingerprint in the glass pieces and it belongs to the accused, which may be a lie. Right? In Crown against Mason, the court stated the evidence should be excluded. Right? Why? Because lying to the lawyer. As all of you know, right, the court has its own workers. But apart from that, right, all the legal practitioners, lawyers, right, everybody, they are all considered to be officers of the court. You can't lie to them. But here I did not lie to a middleman, right? I lied to, here I did not lie to the policeman, but I lied to the defendants, to whom he lied. He lied to the defendant, right? So you should write this, see here. See, although the defense of entrapment is accepted in very few cases, but those who are in extreme situation like Crown against Mason, where the police lied to the solicitor, right? On the fact, it was not a lie to the solicitor, it was just a lie to the defendant. And therefore, most likely this courtesy breach, right, or anything else will not be excluded. All other evidence will not be excluded. Do you understand? Anybody have any issues? So section 78 may not be able to be used. Now the next part, we are going to refusal of legal advice. Now again, refusal of legal advice is something that you have to know, right, by heart. If you refuse legal advice, it automatically goes to legal aid, right? I mean, not legal aid, sorry. If you refuse legal advice, it automatically goes into the logbook record, right? And not legal aid, the duty solicitor, right? The duty solicitor who sit in every single police station will able to help you. But the problem is on the facts is you are calling the duty solicitor. You are not calling your private solicitor, on the facts is you are calling your duty solicitor. Although you are calling your duty solicitor, but he was told that it will take a long time to arrive, and PC Cartwright says the interview will proceed immediately. I'm not calling for my private solicitor, I'm calling for duty solicitor. And even duty solicitor is not available. That's what they are trying to say there. So, if they want to delay legal advice, fine. But they have to satisfy Section 58, Annex B, Code C. Is it an inductable offense? On the facts, what is the offense? Murder. Murder is the offense, right? So, murder is an indictment. The police officer and the superintendent and above authorize it. On the facts, right? It is not really a superintendent, right? It's actually PC Cartwright. PC Cartwright is not really a superintendent, right? Hence, the second requirement is not satisfied, meaning the refusal is not justified, right? The refusal of legal advice is not justified here. On top of that, you can see here the reason, there must be a reasonable grounds as well for refusal. It may interfere with evidence, it may alert the accomplice, it may hinder the recovery of property. Nowhere they have stated, please wait until duty solicitor come, he may probably come late. You can't say that. Do you understand? Any issues? Okay. One of the reason why police officers have actually refused legal advice is also because, see, if you go to the facts, when they first wanted to search his house, he says he's a businessman and knows his rights, but allows the police to conduct a quick search of the house, right? And then he's now requesting for a lawyer or something, but the policeman is telling that, where's that? This part, I think. See, PC Cartwright says that Alex, as a businessman, obviously knows his rights, as there's no problem. This is something that you have repeated earlier. Yeah, this is something that they are repeating back, right? So, what do? You put the case of Crown against Allardyce. What happened in Crown against Allardyce? Right to consult solicitor. The court stated it's an inalienable right. Crown against Samuel, we can dispense with legal advice if the accused don't want so. But the problem is the accused is asking for lawyer advice here. And therefore, any refusal here will not be justified. If you want more marks, you also write note B3 to Code C. Right? Note B3 to Code C stated, refusal of legal advice is a rare occurrence. It's a very rare occurrence. Refusal of legal advice. All okay? Okay. So now, we go to the next part. Here, see. See, towards the end of the question, it was stated, police have found Alex's mobile phone records, including a message sent at 8 a.m. on 24 February to Deirdre, Alex's neighbor. Do you know how to get blood stain off leather gloves? Right? Okay. Let me ask. Is this really considered to be a hearsay? Is this considered to be a hearsay? right? That when you call someone and ask, do you know how to get blood stain off the leather gloves? This seems like a question, right? Right? If it is a question, then it cannot be hearsay, right? It is very difficult for it to be hearsay. Yes, it will not satisfy section 115. Why? Because section 115 is the purpose or one of the purposes of the maker of the statement is to cause someone to believe. But here, when I ask question, I'm not asking someone to believe. What I need is an answer. So based on this, I've said section 115 sub 3A of Criminal Justice Act 2003 is not satisfied. Right? Therefore, it is not hearsay. If it is not hearsay, then it is admissible as. See, I want to tell you this. A lot of people will use this word, will admit as direct evidence, will admit as circumstantial evidence. Do you know what is the difference? If you don't know, don't write. If you don't know, just say that it will be admitted as an evidence. But I put circumstantial evidence. What is the difference? Direct evidence is the evidence that proves facts in issue directly without any further interference. Right? Circumstantial evidence means proving a fact will prove another fact. Proving a fact will prove another fact. That is circumstantial evidence. So what is circumstantial evidence means? Like for an example, you are telling that you are not a murderer, but I found a knife with blood stain on your hand. So I don't have evidence that you stabbed. There's no confession. But if you have a knife on your hand, it's a circumstantial evidence that most likely you are a murderer. Right or no? See, you take into account of any drugs cases. And I take into account of drugs cases. In Hong Kong, I don't think drugs cases will lead capital punishment. But in Singapore, I think if you bring like what, 5 grams of marijuana is enough. 5 grams of marijuana is enough. There will be a capital punishment. You will be hung by neck till death. And most of the people who carries the drugs there, right, they don't know what is in the bag. That's what they'll say. I don't know what is in the bag. So the fact that they are carrying the drugs cannot be taken as a direct evidence because you don't know whether they are really smuggling or not. But it will be taken as a circumstantial evidence because the drugs was on your hand. So proving the drug was on your hand will create a suspicion that you are a drug dealer. That's called circumstantial evidence. Right? So I said, if it is not hearsay, then it will be admitted as a circumstantial evidence, provided it is relevant. And the examiner wants you here to discuss Crown against Twist. Right? In Crown against Twist, again, the court stated this. Can you see what the court stated? The Court of Appeal considered text messages and found that even though they may be hearsay, and hearsay is now potentially admissible under Criminal Justice Act 2003, no court should admit such evidence as a matter of routine or form. Right? Text messages cannot be admitted as a matter of routine or form. The court gave a warning on the fact we also have a text message. So as per the court, as what they said, text messages cannot be admitted as a matter of fact or routine. And you look at the second bullet point, what the court stated. If a text message could be characterized as hearsay, then careful thought had to be given about its reliability and the opportunity for the defense to test it. Only after a very proper analysis, text messages can be admitted. Do you understand? We are done with this case. So what is important here? The most important thing here is actually the part in regards to rare geste, right? Because rare geste rarely comes out in exam, right? But when it comes out like this, then you should know what you're supposed to discuss, right? Otherwise, it will be very much problematic. And I would like to give you a word of caution. In 2023, Zone A, this came out, right? This is 2023, yeah? The typo, it's not 2024. 2023 Zone A rare geste related problem solving question came out, meaning this year in Zone B, it can come out back, right? So you have to be prepared to face the situation, right? Read the article if it is possible, or look at the summary. When last paragraph, plea of not guilty, is there any significance? Attack of bad character? No. Right? I know this, many students will always ask me. Alex pleads not guilty and challenges the admissibility of confession. Right? That means he's just saying that he's not guilty. Right? If they said that, Alex has 7 previous conviction and in that 2 conviction, he pleaded not guilty, but he was still sentenced. Then probably there's a bad character evidence issue here. There's no bad character evidence issue here altogether. Right? So you don't have to worry. So this part that, he pleads not guilty, challenges the admissibility of the confession, blah, 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 it has no relevance. It is actually for just to confuse you. Right? No other purpose other than that. Okay, so we are done with that one question. Okay, you're welcome. Is that when evidence not satisfy section 115, not hearsay? Yes, only when you satisfy 115, it is hearsay. If you don't satisfy 115, it is not hearsay. If it is not hearsay, then it is admissible provided it is relevant. But if it is hearsay, then it is inadmissible. Unless you fall under any one of the exception. Anybody have any question? We will normally consider it is circumstantial, not direct, and the relevant part. IQ is the second part. Wait, we will normally consider it. I don't understand. Can you revise the question back? I don't know what you're asking actually. Right? Meaning, yeah, you can revise then I'll answer. Wait, let him to type the question. So far, anybody else have any question? You can ask me. Okay, there was this question, if evidence not hearsay, not 115, then we should normally consider relevancy in terms of circumstantial, but not direct evidence. No. See, relevancy, right, is actually a different concept compared to circumstantial evidence and direct evidence. Relevant means what? Any facts proving facts in issue is called relevant. Direct evidence or circumstantial evidence indicating that type of evidence. Right? So, this direct evidence or circumstantial evidence can be relevant or may not be relevant. Right? What is direct evidence or circumstantial evidence? Right? It's a type of evidence. It's like, I'm asking what is the model of your phone? Right? It's like, is it Samsung or is it Apple? That is what do we call as direct evidence or circumstantial evidence. Right? Relevance is actually like the specification. Right? That is what relevance. Like your specification, my specification can be same. Your camera is 200 megapixel, my camera is 200 megapixel, same. But the type is different. That's what evidence. So circumstantial evidence can be relevant. Direct evidence can be relevant. Right? Any evidence, any facts that proves facts in issue is always called as relevant. It can be direct evidence, it can be circumstantial evidence. Direct evidence means that evidence proves that you have committed the criminal offense, like CCTV. In CCTV, I'm looking at you carrying a knife and stabbing someone. repetitively. That's a direct evidence. What else I need? Right? But circumstantial evidence is different. Circumstantial evidence is you have a knife on your blood. You have a knife in your hand, right? But I did not see you stabbing. But this may able to prove that you may be a murderer. That's the reason I told you just now. Circumstantial evidence means an evidence that proves other evidence, or an evidence that may prove an AR, not really or directly prove an AR. You get this? Yes, I got. My Q is in exam. If it is not hearsay, do we normally consider the evidence admission through circumstantial evidence? Because just now you say candidates often fail to distinguish. No, if it is not hearsay, do we normally consider the evidence admission through circumstantial evidence? You have to see in your exam, right? Whether it's a direct evidence or circumstantial evidence. Sometimes it will be direct, sometimes it will be circumstantial, right? It depends. But you must, of course, like what you ask, you must consider both, whether it is direct or is it circumstantial. In exam, you can get both, right? Sometimes you'll get direct, sometimes you'll get circumstantial. It depends. Yeah, it's not automatically circumstantial. It can be direct sometimes, right? It can be circumstantial, it can be direct. Okay. Anybody else have any question? So if you have no question, I'll give you a break now. Then after the break, we will look at another question. No problem. You're welcome. Right? Please take a break. Okay, I'm back. Oh, there's actually a question here. Oh, there are two questions. Okay, first, there's this question sent via private message, but it's a long question. So I will just put this in a public chat so that everybody can read this. So this is the question. Hi, I would like to ask, could Cowan direction be applied in 34, not only limit to 35? Could Cowan direction be applied in 34, not only limit to 35? No, it can be applied. Right to silence direction, Cowan direction can be applied in 34, no problem. Right? It's not only limit to 35. The difference between 34 and 35 is just where you remain silent. Right? 34, you remain silent in police station. 35, you remain silent in court. That's all. Is it an exception for the person who give hearsay to be absent in court? Is it an exception for the person to give hearsay to be absent in court due to very ill? Is it an exception for the person to give hearsay to be absent for court due to very ill? If you are like unfit, right? Under 116 sub 2, unfit is actually sub 2B. If you are very ill, that means we will feel you are unfit to give evidence in court. Number 3, is self-confession also regarded as hearsay? Self-confession, if it is heard by someone, it's being repeated in court, then it is hearsay as well. But however, Pringle direction must be given if it is self-confession. I've looked at this when I've looked at lectures with you. Pringle direction must be given because self-confession is actually dangerous. If defense that the evidence is insufficiently reliable, is it regarded as that definition raised no case to answer? DEF means what? Def means, right? I don't know what is def means. If def defense, defendant, oh, okay. If defendant defends that the evidence is insufficiently reliable, is it regarded that the defendant raised no case to answer? No case to answer is not when the defense, or sorry, not when the evidence is unreliable. No case to answer is when the evidence is not to say evidence, when the prosecution has not established a prima facie case against you. That means AR and MR not satisfied. The prosecution has to prove the case beyond reasonable doubt, right? As referred by Lord Justice Viscount Sankey in Wilmington against DPP. So, if the prosecution did not establish the AR and MR beyond reasonable doubt, then the defendant will stand up and say no case to answer, right? Because only when you prove prima facie case, I can answer. Section 100 for bad character on non-defendant can also apply on victim. Yes. Right? See, bad character for non-defendant includes witness and victim. Non-defendant means witness and victim. Not only witness, also victim. If you don't understand, you can ask me back in these 5 questions. Then when we need to discuss no case to answer. The examiner, if you're asking me in exam, the exam question will tell you, right, whether you should discuss no case to answer. The exam question will tell you that the defendant is submitting no case to answer, discuss. You will get a clear indication in your exam that you need to discuss no case to answer. Like the question that we did yesterday, they will spell this out for you. The examiner will write this in the question, please discuss no case to answer. Right? Only then you discuss no case to answer. As I told you yesterday, you don't assume things and write because evidence questions are already very lengthy. Assuming things and writing will make it even more lengthy. You can see here, this is my 3rd day, right? And on average, to finish one question, I'm taking 1 hour. Despite the fact I've given you written outlines, right? So please be careful in regards to that. Excuse me, might I know if I can get this note from email that Poly University sent me before, as I found this. Yeah, I will pass, right? Amanda Poon, I will pass this to Speed tonight. Then you will get all these things by tomorrow, right? Speed will send this to you by tomorrow, right? But meanwhile, if you don't have these notes now, you can ask me. I will actually send a copy to you, but you will get officially via Speed tomorrow, right? I couldn't able to send the notes earlier, right? Because certain questions I had to, like the article summary I just promised to you recently, right? And the 2023 question and the 2022 question I forgot to answer. Sorry, forgot to send, right? So I couldn't able to, do it on time. And the class started, and only when the class started, I saw that. Okay, defender, then we need to discuss. But 2018 Zone A question number 5 did not mention no case to answer. But the answer guide provided no case to answer discussion. 2018 Zone A question number 5. Wait, let me see that question. I think this is actually the Jack question, I think. Right? 2018 Zone A question number 5. This was the question that I've discussed yesterday, right? Wait, just give me a second. I'll go on and get this question in. Two 2018 Zone A question number 5. Okay, yeah, that's a Jack question. Wait, let me open this question. Okay, so I'm sharing this question with you now. This is the question, right? 2018. No, it is stated here. You can see, right? 2018 Zone A question number 5. Right? You can see here at the end of the questions very clearly indicated. Discuss the evidential issues arising, including whether the defense would succeed making submission of no case to answer. Right? It is indicated in the question. Right? As I said, no case to answer. I have never seen so far a question like that. Right? I have never seen a question like that where no case to answer without any indication you have to discuss. It's always no case to answer, there will be an indication. Sorry, can you spell out what is the direction called for self-confession? It is called as Pringle direction. It is in the notes that I've given to you in class during the lectures. Right? It's called as Pringle direction. But, to be very honest, I've never seen Pringle direction in exam, any time before. Even if you take the last 10 years or so, I've never seen Pringle direction. But yeah, it's part of the syllabus. You have to study. I've taught you, but I have never seen Pringle direction in exam altogether. Right? Has never been out before. Any other question? Any other question? Okay. So if no question, then we will go to a magical question now, actually. Right? Why I say it's a very magical question is because it's in page number 6 of the 2023 notes that I've just uploaded right at the beginning of the class. You look at the question, how long? And you look at the answer. Very short, not really that long. Right? I'll read the question, then you'll see. Sometimes, you will get this type of a surprising element in your exam, where the question is very long, but the answer for that is extremely short. After a difficult adolescence, including several burglary offenses, Jack is starting his geography degree studies at non-such university. He attends Freshers' Fair with stalls of different university clubs and societies. At the Stop Gas Now stall, Carl introduces himself saying he is committed climate protest activist and encourages Jack to join, even when Jack confides about his past convictions. Emma, who is starting her degree in history, joins Stop Gas Now at the same time because, as she tells Carl, it represents a cause that is important to her. Unknown to Jack and Emma, Carl is an undercover police officer. Right? When Carl asks Emma to break into the university's vice chancellor's office to steal a list of key contacts at the gas company, she readily agrees and reports back to Carl, who secretly and illegally records her, telling him about how she broke into the office and took the list. Meanwhile, in honor of its supposed efforts to minimize climate damage, the gas company has been given a Climate Protector Award, which has outraged environmental protesters. Over the course of several months, Carl seeks to persuade Jack to steal this award. Relying on Jack's knowledge of burglarizing from his criminal past, Carl offers to pay Jack to help him with this university work and to cook for him, but all to no avail as Jack is adamant that he has put his criminal past behind him. So, Jack is telling, done and, dusted. I'm no longer a criminal. I won't go and steal anything. But finally, Carl threatens to tell Jack's lecturers about his criminal past, and Jack agrees to steal the award. On 6 April 2023, police attend the headquarters of the gas company and arrest Jack as he leaves the building, burglary alarm blaring with the Climate Protector Award in his arms. Jack is charged with burglary of the HQ of the gas company and theft of the award. Emma is arrested the next day and refuses to answer questions put to her in interview about having stolen the list of contacts from the Chancellor's office. Vice Chancellor's office, sorry. Emma and Jack are now due to stand trial. Both having pleaded not guilty, the prosecution will seek to rely upon the recording of Emma's confession to Carl, discuss the evidential issues arising, including any critical comment where you find the law to be unsatisfactory. Discuss. Okay, if you have been following my revision for the past 2 days, you know very clearly that this is actually an entrapment issue because there's a spy. Okay? Right now. Right? So it seems like Emma had confessed, but Carl did not really confess. However, there's a circumstantial evidence here. Why? Because they found the award, right, on Carl's hand. Although there was no evidence that he stole, but they found that on his hand. So therefore, that's a circumstantial evidence. But both pleaded not guilty. So we go to entrapment. Right? As you know, any entrapment, like you are telling that, spy did this, did that and all, any entrapment evidence, right? For any entrapment evidence, we must rely on Section 78 to exclude that. And Section 78 is adverse effect to the fairness of the proceedings. Case on point you have to discuss. This case is not the first time I'm discussing this. Multiple times already. The case of Crown against Loosely, 2000. And what Lord Nichols stated in Crown against Loosely. Lord Nichols stated, if spy police officer, like a James Bond, right, he has actually induced you to commit a crime, we have to see what is the role played by the officer. Is it really an active role? Is it really a passive role? Did he force you? Or did he just give you an opportunity? Right? And you utilize the opportunity. So we have to see whether the police have acted as an agent provocator or not. And in the case of Crown against Loosely, the guideline given by Lord Justice Hoffman is very important. Look at what he said. You have to write this to the examiner as well. First, he said entrapment is not a defense. Entrapment is not a defense. Right? And if there's an entrapment, then probably you can stay the prosecution on the ground that the integrity of the criminal justice system would be compromised, or rarely you can also exclude the evidence under Section 78 of Police and Criminal Evidence Act 1984. But exclusion of evidence under Criminal Evidence Act, Police and Criminal Evidence Act 1984, Section 78, is not really an usual occurrence, because by right, if you think that the integrity of criminal justice system is at stake, and if you think that the evidence should be excluded, sorry, the evidence is actually a dangerous, ill-gotten evidence, then the evidence not only should be excluded, the proceeding must be stayed. So we have to see on the facts whether the proceeding has to be stayed or the evidence has to be excluded, right? Okay. Can you see another case here? William and O'Hare against DBP 1994. You know what happened in this case? Policeman put a van in a park. Inside the van got all cigarette cartons, right? Unopened cigarette cartons, cartons after cartons inside the van. So a lot of people, all the windows of the van were lowered. The key of the van is inside the van. Technically, you can start the engine and drive, right? So many people walk past, so many joggers, right, run across the van. Nobody did anything. But this person, William and O'Hare, these two people, they saw the van, went inside, opened the engine, and they heard freeze with all guns pointing towards them. At trial, they said, you see, I was just running or jogging, right? If if you are a smoker, and if you see that a van with full of cigarette, who won't be tempted, right? Because cigarette is not cheap. They said that this is too much. This is an entrapment. But look at what the court stated. Dismissing the appeal, the police had done nothing to force, persuade, encourage, or coerce the appellants and had therefore not acted as agent provocators. The court still saying that police did not force you. They didn't force you. Just because the van is, all the windows are lowered, cigarette is inside means, does that mean that you can turn into a thief anytime? You cannot justify your criminal act by saying that the van is open and the cigarette is there. Who won't be tempted? You cannot justify your criminal acts like that. So, I just discussed that, right, as an example only. So on the facts, if you look at Emma, it's very clear. Because Carl just asked Emma, the question indicated this. Carl just asked Emma to break into the university's vice chancellor's office to steal a list of key contacts. And Emma immediately say, fine, no problem. Right? So, technically, for Emma, the police only played a passive role, not an active role. But to Jack first, who's that? Carl went and told that I will even cook for you, right? Please go and, steal this award. I can even do your university work, blah, 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 blah. A lot of things. But what Jack said, I'm a changed person. I don't do all these things. I'm so sorry. And then Carl threatened Jack that if you don't do this, I will actually tell your lecturer about this. So only then Jack went and did that. And therefore, I think here, probably Carl has actually played an active role. I mean, you can cook for him, you can do whatever, cooking and, doing his university work. If you stop there, had you stopped there, I would not have said that you have actually played an active role. But you went and threatened him. So that means you have actually played an active role. And therefore, right, I would say that for Carl, right, we should go on and use section 7. Okay, yeah, this is what I have to explain. So for Carl, the police have played an active role, right or not? See, for Emma, if the police have played active role, we can exclude the confession, right? Because Emma had confessed. On the facts, Emma had confessed to the spy police officer Carl. It was secretly recorded, right? So we can exclude the confession, but we decided that to Emma, the police played a passive role, not an active role. But Jack did not confess anything. So what you are going to exclude here? Nothing, what? Right or not? He didn't confess to anything. You look at the question, Jack didn't confess to anything. So what we can do here? He was caught red-handed with the what? Right or not? So what we can do here? If the court allows, we can stay the proceedings. That's the only way here. Stay the proceeding, right? Because the spy police officer went one step ahead, right? Too much for him to do this. Do you understand this? Anybody have any issues? That's it, After right of silence, that's it, done. Right? Can you see how long is the question? But the answer is how short it is. Question is long, but the answer is very short. Okay, so right to silence. Emma refuses to answer any questions, but we don't know whether she's relying on anything in court or not. The question never stated so. So what we can do, we can only discuss section 34. What section 34 stated? If you rely on something in court that you reasonably expected to mention earlier and you fail to mention, then adverse inferences could be drawn against you. So first of all, what you have to know, again, I'm doing this quickly because right to silence is not part of the syllabus for this. It's part of your syllabus, but not part of the syllabus for these 3 days of revision, right? That is actually for your next revision, right? Which is another 10 hours slot. But I'll do this quickly. What you have to know is, you have to see what is something that reasonably expected to mention. What is something that reasonably expected to mention? Right? And number two, you must know that adverse inference is not a rule, right? It is just an option. Nobody can force jury to draw adverse inference. It's just an option. It's not really a matter of fact. So I said that on the fact it's unclear, right? Whatever, whether Emma relied on anything in court that she failed to mention in trial. Anybody have any problem? Okay. So if you have no issues, I want to look at some essay questions. There's a question here to follow. Okay, you can type the question. Yesterday, I looked at some question which has some hearsay essay and other essay questions. So I'm going to look at that outline. Yeah, as a jackpot. Okay, to follow up with Emma, as police role is passive, so the entrapment is likely okay. Then Emma's confession can be admitted, right? Yes, definitely yes. Right, Emma's confession can be admitted. Right, no problem at all. Any other question? So I'm putting a full stop to problem solving questions, huh? Right, I'm putting a full stop to problem solving questions. And all in all, I have looked at 10 problem solving questions with you. Right, 10 problem solving questions. But Jack is another story, likely stay of proceedings. Yes, you are right. Right, because for Jack, the police have actually acted as an agent provocator, in my humble opinion. But for Emma, they have actually acted passively. Okay. You're welcome. So can you all please go to the handout, question 5, 2018 zoning, the Jack handout that I've given to you, the last Jack, right? Question 5, 2018 zoning, that's the handout's name. Okay, I want to look at an essay question there. Can you see this essay question, page number 19? Can you see this essay question? Page number 19. Question for July 2020, Zone B. Look at the question. Page number 19. Question 5, 2018. Question 4, July 2020, Zone B. But it's actually in the Jack's outline. Question 5, 2018, Zone A. That's actually the outline's name, the note's name. Okay, let me read the question. The law on bad character evidence is as incoherent as it is unjust and is likely to result in both wrongful convictions of innocent person and unnecessary unpleasantness for citizens reporting crime. Discuss. Bad character evidence is as incoherent as it is unjust and is likely to result in both wrongful conviction of innocent person and unnecessary unpleasantness for citizens reporting crime. So what are they trying to say is bad character evidence for accused and for defendant and non-defendant, unnecessary, causing unnecessary unpleasantness. Right? That's what they're trying to say. It is causing injustice. It is causing unnecessary unpleasantness. Why? Because if I'm a defendant, you should punish me based on what I've done now, not what I've done 20 years before. Right now. Right? Your AR and MR must be from the current case. Your AR and MR cannot be for what I've done some 20 years before. Right? It cannot be something that I've done for 20 years before. So in this regard, right, in this regard, we have to go on and look at the question. Answer guideline. This essay question is quite easy. Remember, some people will say that if it is an essay question, just vomit whatever you know. That's a very wrong attempt. Some people will actually take last year's answer and discuss, or just write down the last year's outline that I've given. Please remember, although most of the questions are almost the same. Later, I will look at some question review, 2022, 2023 questions. Most of the questions are almost the same, but every year the questions can be different. Sometimes there will be a slight tweak. So please don't copy last year's outline and write in this year's question. Don't do that. Right? It may be similar questions, but it won't be same. Right? It won't be same. It may be similar. Okay, so in my answer guideline, I said bad character evidence is very broad in inclusion of bad character. Right? In fact, while I was looking at lectures with you, I've looked at summary of two articles. One is by Roderick Munday. Another one is James Godcom. Right? You can see my lectures video and the notes that I've given to you earlier. And there are some summaries over two articles. And both of them have actually suggested that bad character evidence, the provisions in regards to bad character evidence under Criminal Justice Act 2003 have been drafted very, very broadly, right? Have been drafted very, very broadly to include almost everything as bad character evidence. So definitely, this may lead to wrongful conviction. Why? Because the law is now making a presumption that if you have committed murder some 5 times before, more likely you are a murderer now. If you have committed rape 5 times before, like yesterday in one of the questions, he has committed rape 7 times before, right? And what I told you, most likely the court will say that he has the tendency or propensity to commit the offense, right? But you cannot make a presumption like this. A person who has committed rape 7 times before probably will change, right? But here, trial is getting very political, right? Trial is getting very political. So, does this really create injustice? Does this really cause injustice? For that, we have to look at the current state of law, right? The current state of law is, what is bad character evidence? You have to write to the examiner, what is bad character evidence? What is bad character evidence? It is actually governed under Section 98 of Criminal Justice Act 2003. Criminal Justice Act 2003 stated, bad character evidence means, right, misconduct. What is a misconduct? Misconduct is defined under Section 112 of Criminal Justice Act 2003 as commission of an offense or other reprehensible behavior. Commission of an offense or other reprehensible behavior. Right? Now, you know that the word reprehensible behavior itself is actually a very broad word. Right? I have indicated this here. Right? What is reprehensible behavior? Reprehensible behavior is not really a word that we often look at in any statute books. Reprehensible behavior is a different type of word. Reprehensible means morally blameworthy. Right? Technically, that is what reprehensible behavior means. Morally blameworthy. And as all of you know, morally blameworthy does not mean legally blameworthy. Right? A person cannot be legally blameworthy if they are morally blameworthy. But right after Section 112 of Criminal Justice Act 2003 and Section 98 of Criminal Justice Act 2003, it seems if you are morally blameworthy, you are also legally blameworthy now. Last time we had this distinction between what is morally blameworthy, what is legally blameworthy. Right? Like for an example, if you have been, drinking a lot, every day you are drinking, you are a drunkard. People will say you are morally blameworthy, but you are not legally blameworthy. Right? Because legally you can drink. Because the law says you can drink, provided you are above a certain age and you are doing this in your own money and you are not causing any public disruption. But it seems now, even that can be taken as a bad character evidence, reprehensible behavior. So, does it really cause injustice? Well, I'm going to look at this now, right? I have actually put some case laws here, and then we will go on and look at some safeguards, and then Roderick Munday's definition, and few other sections, right? And to explain. Okay, first of all, I'm going to look at analysis of case law. So what I've looked at so far, I've looked at what is bad character evidence. Right? And while explaining about bad character evidence, I told the examiner very clearly that as discussed before, it is very broad. Bad character evidence is very, very broad. Right? Because the word reprehensible behavior. Right? Misconduct means commission of an offense or reprehensible behavior. So, the question stated it is causing injustice. The question stated it is actually causing unpleasantness, unnecessary unpleasantness. Well, is it really causing injustice? We will go on and see the analysis of some case laws. Right? Can you see the analysis of case laws? In all these cases down here, the court stated none of this is a reprehensible behavior. Can you see? None of this is a reprehensible behavior. From Roman number 1 to Roman number, I don't know what is that in English numbers, but from Roman number 1 to IX, right? All these things not reprehensible behavior. What is not a reprehensible behavior? 34-year-old man maintaining a sexual relationship with 16-year-old girl is not reprehensible. 39-year-old man making sexually suggestive remarks to 15-year-old girl is not reprehensible. Right? Look at that. Huh? See, if you say first one, 34-year-old man maintaining a sexual relationship with 16-year-old girl, well, at the age of 16, you already major in UK. Right? You can even get married at the age of 16. So, a 34-year-old man maintaining a sexual relationship with 16-year-old girl, probably you will say that depends on them, right? It's their wish. Who are you to question that? Okay, fine. A 39-year-old man making a sexually suggestive remarks to a 15-year-old girl. 15-year-old girl is actually a minor, right? 15-year-old girl is actually a minor. And the 39-year-old man is grooming her. Right? 39-year-old man is grooming her. Then number 3, refusing to make a statement to the police after having been the victim of a knife attack. Okay, this one, some of it you can read on your own. Right? I want you to discuss this too in your exam. Right? And you go on and look at this one. Embellishing a schoolyard incident involving a teacher so as to suggest that the teacher had committed an assault. You know what is embellishing means? Like lying, like doing drama. Right? Falsely accusing a teacher that the teacher had actually committed an assault is not a reprehensible behavior. Right? Now, if you go to the next part, you will see everything that is reprehensible is here. Right? Everything that is reprehensible is here. Now you look at this. Grooming young children, in this case, Sutton, it's considered to be reprehensible. Minister, you can leave it. But in Sutton, it was stated to be reprehensible. Right? And fabricating complaint of sexual assault is considered to be reprehensible here, but it is not reprehensible here. In the case of V, in the case of Crown against V, it was not reprehensible. But in the case of Henson, it was reprehensible. Right? And you look at here, Hindu priests making sexual advances towards female members of the congregation. The case of Crown against Somanathan. It's reprehensible. But if you groom a 15-year-old girl, a 39-year-old man grooming a 15-year-old girl is not reprehensible. What you understand from this analysis? What I understand is, until now, see, the question said, bad character evidence is as incoherent as it is unjust, and is likely to result in both wrongful conviction of innocent person and unnecessary unpleasantness. So they say it is incoherent. What is incoherent means? Not uniform, right? Like one fellow saying one thing, one judge is saying one thing, another judge is saying another thing. That's what we have looked at just now, right? Now, so I'm telling the examiner that it is incoherent as what the title suggests, as what the exam question suggests. It is incoherent because in similar situation, one case is telling yes, it's bad character evidence, another is telling no, it's not bad character evidence. It's incoherent. Whenever a law is incoherent, it can cause injustice. So I agree with the title. I agree with the statement by the exam question. It is incoherent and therefore it causes injustice to the defendant, to the witness, to the victim. Do you understand up to here? Anybody have any question? So that is actually our conclusion, not conclusion, but that is our stance. That because it is incoherent, therefore it may potentially cause injustice. Because it depends now on the judge. If you got one judge, he will say that's not bad character. If you get another judge, he will say that yeah, it's bad character. But after all, Criminal Justice Act 2003 has actually made some damage control here. Criminal Justice Act 2003 has some safeguards, right? Criminal Justice Act 2003 has some safeguards where it can actually reduce the damage. That means any injustice can be reduced. And what are the sections that we can rely on? Section 101 sub 3. As all of you know, what section 101 sub 3 stated? When there is an adverse effect to the fairness of the proceedings, then the evidence ought not to be admitted. Section, there's a typo here. This is section 103 sub 3, not 1013 sub 3. This is section 103 sub 3. And what section 103 sub 3 stated? For the reason of length of time, right? For the reason of length of time, if it is unfair to adduce that evidence as bad character evidence, then the evidence should not be admitted as bad character evidence by reason of length of time. Do you understand? And on top of that, we have section 78. Section 78 can be used in almost exclusion of any evidence because it's a broad evidence, broad exclusionary section actually. Section 78 of Police and Criminal Evidence Act 1984. Then section 82 sub 3 also can be used. 82 sub 3 of Police and Criminal Evidence Act 1984. Prejudicial effect outweigh the probative value of the evidence. This is by following 82 sub 3 is by following the case of Crown against Sang. Right? By following the case of Crown against Sang. Okay. Anybody so far have any issues? So what we'll do, so you must tell the examiner, remember, you must tell the examiner that so far, although we have some sort of incoherency that may result in unjust cases, unjust judgments, unjust decisions, that may cause some unnecessary unpleasantness to the victims or witnesses, but there are some damage control, right? See, these are the damage control that we discussed concerning the defendants. For non-defendants, the damage control is part of section 100, right? Section 100 is so broad that we don't need to exclude it, right? Because, see here, let me put section 100 here, then you will know why we don't need any exclusionary section there. Criminal, wait, let me put this in. Okay, let me share the screen. Sorry. Okay, can you see here? This is section 100. Non-defendant's bad character under Criminal Justice Act 2003, right? In criminal proceedings, evidence of the bad character of the person, right? In criminal proceedings, evidence of the bad character of a person other than the defendant is admissible if and only if it is an important explanatory evidence. That's background evidence. All of you know what is background evidence means. For defendant, background evidence is given under section 101 sub 1c, right? B, it has substantial probative value in relation to a matter which it's a matter in issue in the proceedings and is of substantial importance in the context as a case as a whole. Normally, everybody will use B only. Nobody will use C, right? C is all parties to the proceedings agree, which you know will not happen, right? Will not happen. Only they'll use P. It has substantial probative value in relation to a matter which is a matter in issue in the proceedings and is of substantial importance in the context of case as whole. Can you imagine how difficult to bring a bad character evidence of the non-defendant? Not only I have to prove it has substantial probative value, I must prove that it has substantial probative value in a matter and issue in the proceedings. And for the whole case, it must be important as well. Otherwise, I cannot adduce this bad character evidence against the accused, against the non-defendant, who can be a witness, who can be a victim. You understand what I'm trying to say? Right? So, please remember, right? Please remember that non-defendant bad character, you don't have to take this into account. I mean, you have to take this into account, but exclusions need not to be given, right? It wasn't given anywhere. Why it wasn't given anywhere? It's because the section itself is broad enough. That was the reason. Okay. So, I want to look at now is, I go back to my answer outline. And you can see, right after I discuss this, if any of you lost what we have done, we have looked at the definition of bad character evidence. We have looked at 98.112, right? And then we went on to tell the examiner, as what the title suggests, the regime of bad character evidence is incoherent. We do agree with that. And after that, we say, however, we have some damage control, right? And now what we are going to do, we are going to look at Rodrigues-Mundy's evaluation, right? Whether what he thinks, does it really create injustice, or bad character evidence is something that is needed? This is based on, right, whatever I'm explaining to you now is based on Rodrigues-Mundy's article called What Constitute Other Reprehensible Behavior under the Bad Character Provisions of Criminal Justice Act 2003. Right? Okay. So Rodrigues-Mundy stated this. See, the question here is, Bad character evidence is incoherent and therefore it is creating unjust cases. Right? So this is what Roderick Munday stated. Roderick Munday stated, first, Criminal Justice Act 2003 is designed, right, to actually bring bad character evidence more frequently than before. More frequently than before the arrival of Criminal Justice Act 2003. Why? See, under the old law, right, before CJA 2003, right, we had this case TPP against P, and also we have the case of Botman against DPP. In both of these cases, it was stated that on bad character evidence is only admissible, right? I write here, bad character evidence is only admissible if it is strikingly similar. I've discussed this while I was looking at lectures with you. Only if it is strikingly similar. That means the way that you conduct the crime was not only similar, strikingly similar. That means very close. Like after you commit murder, you go and spray, right? Go to hell on the victim's body. And now also you have done the same thing. So we can take the previous offense. If you committed murder this time, last time also you committed murder, that's not bad character evidence in the previous law. Before CJA 2003. Because it must be strikingly similar. But after CJA 2003, you can see, after CJA 2003, you can see that they even take into account of reprehensible behavior. So, reprehensible. So, from being merely taking into account of whatever strikingly similar, now it need not to be even strikingly similar. It need not to be even commission of an offense. It can be of anything. That's the reason Roderick Munday is trying to say the act is designed to bring bad character evidence in more frequently than the previous regime. Do you understand this? Anybody have any issues here? So, second, Roderick Munday stated, if you still refer to my lecture, in my lecture I stated this. When Law Commission proposed this, right? When Law Commission proposed this particular thing, right? Reprehensible behavior, Law Commission have actually suggested this test for reprehensible behavior. They said that reprehensible behavior is something that always viewed with disapproval by a reasonable person. What is reprehensible behavior? It is a behavior that is always viewed with disapproval by a reasonable person. That's what Roderick Munday stated. Well, Parliament has actually removed that from Law Commission's proposal. Meaning Parliament wants reprehensible behavior to be given the widest interpretation. Don't bring reasonable man, don't try to define it. We also won't define, you also won't define. That's what Parliament's intention is. So, Parliament, it's not whether, it create unjust cases or unnecessarily unpleasant. But if you think so, it's a Parliament who wants it. Parliament wants to do that. And because of this, Roderick Munday stated, he identified 3 things in the new act, right, for bad character evidence under Criminal Justice Act 2003. First, he said, the new law and old law is same in regards to one thing, that is, evidence of the bad character evidence is inadmissible unless an exception to that rule is available. If it is bad character evidence, it is inadmissible unless one of the exception is applicable. I repeat again. Bad character evidence means it is inadmissible unless one of the exception is admissible. Same like hearsay, right? If hearsay means inadmissible unless one of the exception is applicable. Right? So, only by virtue of the exception, bad character evidence is applicable. Second, Roderick Munday stated, can you see this part? There's a principle that ambiguity in statutes that impose penalty or burden should be resolved in favor of defense. Right? This is a principle that's an unwritten rule. Right? Unwritten rule is whenever the statute never define anything, the best possible interpretation that is advantageous to the accused must be taken into account. And because reprehensible behavior is not defined, right, we may have to take into account what is best for the accused, right? But you see, Roderick Munday is trying to say this. See, in view of the enhanced risk of conviction, defendant run once a bad character has been revealed in court, the ambiguous provision of the new bad character regime look to qualify under this principle of statutory construction. He's trying to say that reprehensible behavior is always resolved in favor of the defendant. I don't think so, right? Defendant's bad character evidence or reprehensible behavior are the one that we are admitting as bad character evidence. If everything's supposed to be favoring the defense, then nothing will be taken as a bad character evidence. And number 3, you will only admit bad character evidence when it is justifiable, when it's really needed. This is what Roderick Munday stated. Anybody have any issues here? All okay? But so Roderick Munday is trying to say Parliament wants to allow reprehensible behavior, and that has actually not only reprehensible behavior but bad character evidence entirely. And because of the broad inclusion, it has made the case laws incoherent. So the reason is Parliament. But if you look at James Godcombe is also written an article in regards to what is reprehensible behavior. And in that article, he also evaluated what Roderick Munday stated. But James Godcombe trying to say, Roderick Munday, right, never really analyzed the act properly. Right? Because Roderick Munday trying to say, yeah, it is creating injustice, it's creating unnecessary unpleasantness, it is creating this, it's creating that. But it's the Parliament who wants it. But James Godcombe stated something very beautiful, right? Look at what he said. He said this. He said, look at here, this part, page number 22. The more liberal the reading afforded to the words reprehensible behavior, the less likely it is that evidence pertaining to the character of the defendant or non-defendant will be admitted. Now, can you imagine that what he's trying to say, James Godcombe? He said, Roderick Munday said, Parliament wants to allow everything in as a bad character evidence. But Roderick Munday trying to say no. I mean, they made it broad, but you know why? Because when more and more fall as a bad character evidence, meaning it is inadmissible. So, just like what Roderick Munday stated, it is inadmissible and only by virtue of the exceptions it is admissible. And therefore, if you come under section 101 or if you go under section 100, it's subject to many filters. What are the filters? We have 101 sub 3, when there's an adverse effect to the fairness of the proceedings. We have 103 sub 3, by reason of length of time, the bad character evidence can be rejected. We can use section 78, when there's an adverse effect to the fairness of the proceedings. We can use section 82 sub 3, which is the prejudicial effect of the evidence outweigh the probative value. If you go under section 100, I just looked at this with you. It must have substantial importance, right, to the case as a whole and to the point. So there are so many filters there. So James Godcombe trying to say, Parliament made it so broad. The reason is because Parliament wants more and more to fall under bad character. Only then it can cross the filters, right? So most bad characters will fall with the safeguards under section 101 sub 3 and 103 sub 3, 78, 82 sub 3 and others. See, this is why is it. This is because evidence that constitute a bad character evidence has to overcome the barriers to admissibility posed by 100 or 101 before it can put before the trier of fact. Right or not? So, go down. Can you see here? Conversely, the narrower the interpretation, the more likely it is that such evidence will be admitted. Section 100 and 101 fall away if the evidence in issue is not a bad character evidence. Look at here. If it is bad character evidence, then it is inadmissible unless you fall under the exception. But if you never make bad character definition very broad, then many evidence will be taken as non-bad character evidence. If it is not a bad character evidence, then it is admissible provided it's relevant. There's only one filter, the relevancy. And relevancy can be very easily satisfied. But if you fall under bad character, how many filters are there? So did Parliament created this or made it broad to cause unjust cases or to cause injustice, to cause unnecessary unpleasantness, or because they care of you, because they want only the true bad character evidence to be admitted? Because if it is not bad character, it's admitted provided it's relevant. One filter. If you come under bad character evidence, so many filters. Am I right or not? Do you all understand what is this about? Anybody don't understand? So what we did, we look at bad character evidence definition and we say that it is too broad, right? And then we went on to look at analysis of cases and we say that it's incoherent. Because it is broad, it is causing incoherency, right? Then after that, we went on to look at Roderick Munday, who support our view, who said that yes, it is broad and Parliament wants to make it broad. And because it is broad, that's the reason it is subject to multiple interpretation. That's the reason it's causing incoherency. But James Godcom is trying to say otherwise. It has opened our mind now. Did Parliament really wants to make it broad? I don't think so now. Because it seems that they want more and more to be a bad character evidence so that you will go under a lot of filters there. Do you get this? So in this view, right? I mean, with this view aside, there's a question. Just to clarify that these 3 points are Godcom's critique to Munday. More bad character evidence, then more subject to 100 and 101. The 3 points above there, it is actually Munday's evaluation. These 3 points are from Munday, Roderick Munday. Right? This part is where James Godcom is evaluating Roderick Munday. So, as what you asked, when you go into bad character evidence, so a lot of filters, 100, 101 and a lot. Okay. So now you can look at some specific examples. You say there's causing unpleasant or unnecessary unpleasantness, right? We said that, just now that it is actually causing unjust cases, right? Bringing injustice. Is that really true? You guys know this. We have 101 sub 1D. We have 101 sub 1D, which all of you know, right? And in section 101 sub 1D, initially Law Commission stated any evidence under 101 sub 1D must be admitted with the leave of the court only. You must admit this with the leave of the court. It was dropped, right? And Law Commission also said that the court have to be satisfied that either evidence carried no risk of prejudice to the defendant or taking into account of the risk of prejudice, the interest of justice nevertheless require it to be admitted. Dropped. Parliament dropped that. They also suggest important matter in issue between the defendant and prosecution only goes to propensity to commit the offense, not to propensity to be untruthful. That is also dropped. Law Commission said we use similar fact evidence only. That means strikingly similar cases only to establish bad character evidence. That is also dropped. Everything here dropped. And they just barely admitted something. Right? Which is the reason why some people consider that there is a, incoherent cases. Right? Incoherent cases. But that is what the parliament wants. If you go to propensity to be untruthful, again, test under Campbell, test under Hansen. I have discussed this before. So I don't want to discuss this back. Test under Campbell, test under Hansen. You may write this and you can tell the examiner, right? Despite of the fact, Parliament wants many bad character evidence to fall under bad character and to filter it, but certain areas, right? Certain areas without definition really causing a lot of incoherent cases. Like Campbell, Hansen, two different tests. Do you see that? So, what is our conclusion? See, I've also discussed 101 sub 1G here, but you discuss either 101 sub 1D or 101 sub 1G. You don't have to discuss both. I repeat again, you don't have to discuss both. You discuss either one only. So our conclusion here is like this. First, did bad character evidence give birth to a lot of incoherent cases? Yes. Did it make bad character, the regime of bad character is very broad? Yes. Is it causing unjust, unnecessarily unpleasant cases? Prima facie, yes. And then we decided that the parliament's intention may be otherwise. They want more and more to be bad character evidence so that it can go through a lot of filters. But our real conclusion is it is appreciated that the parliament wants more and more to be bad character evidence because it will go through filters. However, certain areas really need definition so that this unjust or injustice can be prevented. The intention of parliament is noble, but to prevent injustice, we need some case law definition or some statutory definition. That's all. We are done. Do you get this? Anybody have any issues? That's one of an essay question, right? And if you go on, okay, if you go on and look at 2023 questions, let me show you the 2023 questions. Wait, let me show you the 2023 questions. Okay. So this is 2023 Zone B. Right? 2023 Zone B. If I go down, can you see here? First question. It's the same. Right? Can you see here? Do the provisions of Criminal Justice Act 2003 deal adequately, right, with the dangers of bad character evidence concerning defendant and witness? That's exactly the same. You have to discuss bad character and you have to tell the reason why. Many people think that reprehensible behavior means parliament is very evil. Parliament wants more and more bad character evidence to be admitted so that they can put people in prison. But after James God come, that's not the real intention. The real intention is they want more and more to be a bad character evidence so that they can actually try to go under some filters. You get this? Right? And if you look at this is 2023 zoning, right? Can you see here? The rule of evidence should facilitate rather than obstruct the search of truth and should simplify rather than complicate the trial process. Discuss in relation to either evidence of bad character or hearsay evidence. And for bad character, you have to discuss the same thing. For hearsay, the essay questions I've discussed. Right, this is hearsay and human rights. The essay question I've discussed that during my lectures, and I said I won't revisit that during revision because it will be the same. Right, so for essay question on hearsay, you have to refer to my lectures that I've done. Right, it's actually the same thing. Right, it's actually the same thing. Okay. See, I want to show you. I want to show you one more thing. You will be surprised by this. You look at question number 2. If the prosecution case rests entirely on circumstantial evidence, then the judge would always correctly accept a defense submission of no case to answer. Discuss adding critical comment where you think the law is unsatisfactory. Do you know how easy it is? Yesterday we have looked at this. You just have to copy and paraphrase and write that again in your own words. That's all. This statement is wrong. Right? This statement is wrong. Right? Because a submission of no case to answer will not be made only for circumstantial evidence. It's not circumstantial evidence, not direct evidence that caused submission of no case to answer. Submission of no case to answer is only possible in cases where prosecution has not established a prima facie evidence. That's all. And you look at what the examiner stated. AB against CPS, yesterday I discussed. Sardar, yesterday is in my notes also. Galbraith, that's all. You just copy and paraphrase and write that this essay question is done. Exactly similar to what I've looked at in problem solving. You don't trust me? You go and see. Yesterday I discussed this case with you. This case is also in my notes. Only 3 cases you have to discuss. That's all you are done. Just 3 cases. You don't have to discuss anything more than that. Do you understand this? Okay. I want to give you a very short break. Once I come back, I will look at the rag ST article evaluation. Right? Please be prepared for rag ST. Again, I repeat, rag ST may be an essay question. Rag ST may be a problem solving question, but even in a problem solving question, you have to critically evaluate some controversy. Right? So take a short break. Then after that, I will discuss about the rag ST essay. Okay, I'm back. And we are at the final half an hour, right? Where we are going to look at this summary of RAG ST article. See, again, I'm emphasizing on this a lot. You should know why, right? It's because I really think it's going to come on, right? And to give us an indication, last year, 2023 Zone A, it came out. And we have looked at that problem solving question as well. So it could be a problem solving question, could be an essay question. But remember that even if it is a problem solving question, you still have to discuss a little bit about RAG ST. The examiner will expect you to do that, right? The examiner will expect you to do that. The reason is because this year it's being controversial. There's an article. This article only was published in 2023, around November or December, I think. Right? If I'm not wrong, around November, December. Right? So that it's a recent article. Right? I've also passed you the entire article yesterday. Right? But this is a summary. Right? I will also pass a copy of that entire article as well. Okay, so this article name is Fight, Flight, Freeze or Lie. Rethinking the principles of RAG ST evidence in light of its revival. Right? Okay. So what we will do now is, this article is divided into a few parts and I'm going part by part. Right? I'm going part by part. This article says that RAG ST is a useless thing to retain. It's causing a lot of confusion. Right? Case law is not really proper as well. So it's like
Sorry.
is there anybody like speaking? Okay. I think probably you wrongly have actually on this, right? Okay, never mind. I've muted it. Okay, so it's just saying that it's it's an unwanted development, RAG ST. Okay, it's developed ready, but right now, please abolish it. That's what they are trying to say. Right? So, in fact, they are actually discussing this in regards to England and Wales. In England and Wales, it is called excited utterance. Right? And don't ask me where is Scotland here. In Scotland, they have a separate law. They do follow evidence, but they do have a separate law as well. Right? So if Scotland is not here, Scotland is not here. Please don't go and question why Scotland is not here. Right? And in US, we call that as excited utterance. In England and Wales, we call that as emotionally overpowered statement. Right? And in US, we call that excited utterance. So first of all, the article discusses the background and the current law. Right? So when it comes to the background and current law, we have to go part by part. Right? Because US and UK law both are included. If you discuss this, you will get good marks, Because let me tell you, only very few students will go on and discuss RAG ST as to US. And via this article, you know about RAG ST in US as well. Remember, this article is 22 pages. I know many of you won't have time to read that. 22 pages is not really simple to read. Reading is different. Understand and reading is two different things. Evidence law articles, sometimes you have to read 4 or 5 times for you to understand. Right? When I was a student, I was also like that. So I made it as simple as possible, but the gist of what is in that article is here. Right? Nothing is lost in quality. Just lost in quantity only. Right? Not in quality. So first of all, emotionally overpowered statement in England and Wales. This is actually part of section 118 sub 1 sub 4A of Criminal Justice Act 2003. As all of you know, section 118 is called as preserved common law exception. And this RAG ST has existed since 1600. RAG ST has existed since 1600. So since 1600 until now, right, until Criminal Justice Act 2003, it was part of common law principle. And in criminal law, in Criminal Justice Act 2003, it was introduced as an act, section 118. Right? And under section 118, right? If you look at section 118, we have 3 type of rag estate. The first one is, right, excited utterance, or what they call that as emotionally overpowered statement. Right? Then number 2, we have statement accompanied by an act. And number 3, physical or mental state. Emotionally overpowered statement means it's like that. I slap you and oh, what you did to me. That's emotionally overpowered. Statement accompanied by an act means, like I'm telling this now to you. Please touch your nose. Automatically hand goes there. When I say turn right, guys, automatically my head goes towards the right. Whenever there is a statement accompanied by an act, you can't lie. Possibility of concoction, distortion will be disregarded. Physical or mental state, like, you know, if you take a flower and then you smell it and then you say, what a nice flower. Right? You cannot be like, what a shit smell. It's not like that. You can't do that. Right? Or if I'm slapping you and you're like, that's a physical state, pain. Do you see that? It cannot be like, wow, what a nice feeling. It cannot be like that. If I slap you, it's like, right? Would anybody will say if I slap you, what a nice feeling? Obviously, they won't, because it will be painful. That's what physical or mental state. Right? But the main point here is any possibility of concoction or distortion must be disregarded. It must be such a possibility. So the court have actually laid down the rules in Crown against Andrews 1987. Right? Crown against Andrews that we have looked at just now. Right? In our first question today, where Ockner's test was actually, Ockner's criteria was established. The 5 criteria that I've looked at the beginning of the class for rag estate. There's a case of Crown against Andrews. Right? This test established the possibility of concoction can be disregarded test. But Crown against Andrews always focus on aftermath. That means Crown against Andrews is like a very mathematical test, if you see. Like, you know, just now Bedingfield, remember? Oh, Anne, look at what Harry did to me. She just stepped out. She opened the door and say, oh, Anne, look at what she did to me. The court stated, sorry, that's not rag estate. Got time lapse ready. So, Crown against Andrews only looking at that time. They are not looking at the quality of the evidence. They're only looking at that time. That's why I say, I mean, that's why in the summary, the author of the article said, is focusing on the immediate aftermath of the event. Nothing more than that. The only consideration is how many seconds have passed. If it is like, pop, and they will say, oh, rag estate, rag estate. If I slap you and you're like, God, what you did to me? They say not rag estate. Because they say 5 seconds pass, sorry, cannot. Would anybody will shout like that? You imagine that? It won't be that instant. Right? It won't be that instant like that. Even if you stab someone, for the brain to accept that something happens, you know, normally what you watch in movie, when I stab you will be like that. Right or not? It cannot be like, you know, like, it's not like that. Now you see, Crown against Gorman, 2019, very recent case. Crown against Gorman, 2019. This case demonstrates court's willingness to label evidence as compelling rag estate despite absence of emotional empowerment based solely on immediacy. Crown against Gorman 2019, which is a very recent case now, is trying to say that we are only looking at the expression and the event. We are not looking at the time and seconds strictly. You can even shout after 20 seconds or so. No problem. But rageste means what? Part of the story. So we look at your emotional overpowerment, like an involuntary movement of muscle, rather than the time. This is the law up to now in United Kingdom, right? And a lot of scholars are trying to say rageste is not needed because timing, looking at timing like that, 10 seconds, 20 seconds, 30 seconds, not going to pay off anything. So therefore, we strictly look at 114 sub 1D, right? Where all rageste will be admitted if it is safe. That's a law in United Kingdom. The law in United States of America is a little bit different. The law in United States of America, it's in Federal Rules of Evidence, FRE, under Rule 803 sub 2, right, which is to allow for the admissibility of excited utterance in court, assuming that statements made under this test, stress of a startling event are inherently trustworthy. So, the statement must be made under the stress of a startling event. Under the stress of startling event. What is startling event means? Startling means like something like make you like fearful, right? Like that's called startling, right? So the test there is stress of a startling event. Now you look at their case. They have this case called People Against Simpson. Right? Can you see? People Against Simpson. Complainant admitting to lying during a 911 call shortly after the alleged event, challenging the premise that the stress guarantees truthfulness. People call 911, and like making a joke. Oh, my house is burning. Please come, please come, please come. Put down the phone. Now, you really look at this, it looks like a stress of a startling event. But people can also joke about this lying. So the stress can be manufactured. If I ask you to behave like panic now, can you behave? Yeah, definitely can. Davis against Washington, 2006. Can you see? Davis against Washington. US Supreme Court clarify the testimonial nature of certain statements affecting the application of Rule 803 under confrontation clause, showing the nuanced consideration required beyond a mere emotional state. By US Supreme Court, right, trying to say certain statements, right, are very much testimonial. It's like right after you stabbed me and you ran away, and then someone came, and I am not really like telling startling thing. I'm telling that don't forget who did this to me, that is John. He stabbed me. It's not emotionally overpowered thing. Emotionally overpowered means you call somebody and say, look at what he did to me. He killed me already. Yeah, that's emotionally overpowered. You stabbed me and you ran away. Someone come in and then you're telling, remember this, before I die, John did this to me, right? Do something to John. Send John to prison. I want to see him behind the bars. You die. The court stated that's a testimonial statement. It's not really excited utterance. All right? It's nothing to be excited there. It's a testimony. So, people want that spontaneity, but some spontaneity are fake. Some for spontaneity are testimonial in nature. Whereas you go to UK, they're only looking at the seconds. 10 seconds, no, not rageste. 2 seconds, rageste, no problem. Right? This is the current law all the way. So what is the problem in regards to current law? Misapplication and unnecessity. Right? There are a lot of contradictory judgment because in United Kingdom especially, because the court take into account of time as a factor. They are not looking at whether, see, they say that you must be emotionally overpowered. But how, if you go and ask them how you know I'm emotionally overpowered, they will say that we look at that time. If I slap you, immediately shout, emotionally overpowered. After 10 seconds, or sorry, not emotionally overpowered. So they have made time as a factor of regeste, which is wrong. That's what the article trying to suggest. What's wrong in bringing 1/1 sub 1D here? Am I right? Second, scientific and psychological foundation. Apparently, I mean, this article, this author made some scientific research as well. He even went and communicated to neuroscientists. And then modern neuroscience, according to him, he published the research result. Modern neuroscience contradicts the premise that people are more truthful under emotional stress. Neuroscientists are trying to say when people are under stress, they will lie more often. So technically, from your biological nature itself, when you're under stress, you will lie. I just give you an example. Let's say today you kill someone. The dead body is in your house. Would you think of how to hide the dead body and how to lie to people to hide this crime? Or would you be telling truth to people? Would you be like calling your friend and say, I killed Freddy? And then you put in your Facebook, today I've killed someone. Right? I just want to be truthful in my life. Do you think you will do this? No. Stressful situation will always give rise to liars. If you committed a crime, you will think of how to hide from that, how to escape from that. You won't be thinking, okay, let's open my Twitter, which is now known as X. Let's post that, right? I did this. Let the world knows I'm a truthful person. Nobody would do that. So the research that he did, the research shows stress can impair cognitive functions and memory, and people can lie quickly and convincingly under stress. You go and take that. If you are reading the article, he put a full research result there. So that's the second criticism. Third criticism is perpetuation of stereotype. See, perpetuation of stereotype means there are certain stereotype about victim behavior, right? Especially when it comes to domestic and sexual violence. See, what are they trying to say is this. If you, let's say, go for a domestic violence or sexual violence, right? Okay, let's say take domestic violence. Domestic violence, let's say the husband beat the wife every day. Every day the wife will take it, right? And she will cry, she can't take it, but still she will keep it in heart because it's like a common thing already. Do you see that? Sometimes when, domestic violence, husband come and slap the wife were kicked. She won't cry immediately because she was like, my life is like this already. What am I supposed to do? When the husband left, half an hour, 1 hour later, she will sit somewhere and cry. And if you go to rag estate, someone heard this, someone wants to come and tell in court, the court will say this is not rag estate. Husband beat you when? 2 days before. Why you are crying? Oh, because husband was in my house for 2 days. If I cry, he will beat me again. So what you supposed to do? I have to wait until my husband goes for holiday or somewhere, then only I can cry. Oh, so that's not a rag estate. Because 2 days have passed. But in domestic or sexual violence, sometimes, I'm not talking about immediate rape. You may have read in newspaper in many parts of the world, father raped the daughter repetitively for the past 20 years. The daughter kept it in her heart. She don't cry immediately. She kept it. And then let's say 1 week once she cry. When the sexual violence happened? On Monday. When you cry? On Sunday. Not everybody will show the emotion instantly. Some people will keep it in heart. Some people will immediately burst out. For all this reason, the article trying to say, rag este is not really right to be retained. So why? Lack of scientific support and inconsistency with victim behavioral understanding, because people can lie. So what is the reform that they suggested? First reform, abolish the exception, right? Abolish. And abolition do what? Section 114 sub 1D can do good job. In the interest of justice, if you want to bring this statement in, bring in. You know, section 114 sub 1D can use for any type of hearsay, multiple hearsay, first-hand hearsay, documentary hearsay, any hearsay can be brought in under section 114 sub 1D. Right? So that's why they say utilize existing framework. Right? In England and Wales, you can use interest of justice test and re-evaluate legal assumption. Right? What is the legal assumption? The legal assumption is when someone react immediately after a stressful event, they won't lie. This legal assumption must be re-evaluated because, see, let me tell you, I don't know whether you guys have realized this or not. See, some of you here born in 70s, probably 60s, I don't know. 80s, right? You see, those who born in 70s, 80s all would have a different level of intelligence. But if you realize, kids who born after 2000, exceptionally intelligent. Especially, you know, if you see that kids who born after 2010, they know how to use iPad, they know how to use computer. Whereas the time that you born, probably 20, 25 years in your life, you don't know what is computer. Because at that time, computer wasn't really that norm. So we handle stress differently. Right? When you probably have stress, you go and sit in one corner and cry. When these 2K kids have stress, they will go and type in ChatGPT how to handle stress. Different people handle stress differently. And some people can lie in stress. Some people will cry in stress. That's the ideology here. So the conclusion that they make here is excited utterance had to be dropped because of all this reason. So if it comes out in a problem solving question, right, you discuss these two cases. And this case, you have to discuss the Ockner criteria, right, that I've looked at the beginning of the class. And then, because they say that evaluate the area that is controversial, right? Every problem solving question carries this line at the end of the question. Then you discuss US also like that. But a lot of people have actually made fun by calling 9 and 11 and acting like, you know, it's a distress call whatsoever. And then scientific evidence not really in favor of it. So because of that, what we can do, we can use section 114 sub 1D. If you say like that, your problem solving question will get good marks. But if it is an essay question comes out, you carry this into exam hall and you broaden this and write, you will get your marks. Either way, I really think rag essay going to come out this year, for sure. Anybody have any question? Okay, so we are towards the end of the class, right? Normally towards the end of the class, I will give the prediction what's going to come out. But in evidence law, it's not possible. You know, in every question, everything will be there, right? So I cannot tell you that, you know, expert evidence is going to come out, bad character evidence is going to come out. So my advice to you is, please study everything. Please prepare for everything. Don't skip anything, right? That is the best advice anybody can give for evidence law. Make sure you know a little bit on everything and everything in that little bit. Meaning to say, study everything, right? Don't skip anything. After this, you will have section 41 and all others. Please do focus on that as well, because you don't know, right, in which question what will be asked. Okay. So, see, some of you have my phone number as well. If you don't have my phone number, this is my phone number. You can search me in WhatsApp with this phone number. Just save my number. I will appear in WhatsApp. My advice is, if it is possible, you send me WhatsApp, you will get reply faster. If you send via email, you will get reply, but it will take a few days. Sometimes it will probably take a week or plus. But I can tell you my email box is full, right? Because revision is happening in Malaysia, 2 locations in Hong Kong. So many students are, you know, bugging me, right? So you send to my WhatsApp, you will get answer very fast. Right? I can instantly answer. But if you send to my email, then please wait. Give me some time, then I will reply. Anybody have any issues? So whatever new material I've updated here, I will actually pass it to Speed Office in a while. So you will get this officially tomorrow. Recording I will upload. And if nobody have any question, then I will wish you all the best for your exam. Right? Just a piece of advice. Don't copy from my notes and write exactly. Please rephrase and write. Please paraphrase and write. Don't write exactly from my notes. Anybody have any issues? Okay. So if no issues, thank you very much. Right? And I hope all of you will get graduated. Right? If this is your final year, all the best for your exam. Bye.